Mr. McCabe, if you want to proceed with our final case today, Laurent versus Panamset and St. Paul.
Yes, Your Honor. It's a pretty simple issue in this case. May it please the Court, my name is Bill McCabe, and I represent the claimant, William Laurent. I'll reserve 2 minutes for rebuttal.
All right.
In this case, the Judge of Compensation Claims found that the claimant's claim for benefits is barred by the statute of limitations. In reaching this decision, the judge found that the request for assistance which the claimant filed and timely, or within the 2-year time period, did not toll the statute of limitations. And that's the issue that we contend is error. The claimant's accident occurred on June 2nd, 2001, and therefore she had to file her petition for benefits within 2 years or by June 2nd, 2003, or it was barred. At the time of the claimant's accident, a request for assistance was a pre-petition requirement. However, on July 1st, 2002, the statute was amended and no longer is a request for assistance a pre-petition requirement before you can file a petition for benefits. And the court held in Zabik versus Palm Beach County School District that that was procedural, not substantive, so it would apply to anything filed after that. Now, we acknowledge that when the filing of a request for assistance was a pre-petition requirement, the filing of the request for assistance did not toll the statute of limitations, was not considered a claim, etc. And there's 3 cases I cited in my brief where the court held that. However, we would submit that when the request for assistance is not a pre-petition requirement, then the filing of a request for assistance in and of itself should be sufficient to toll the statute of limitations. There's one case that we rely on. Basically, it's Sanchez versus Acapulco.
Wouldn't we have to find that the request for assistance is the same as a petition for benefits?
Are you asking me if it is the same?
I mean, wouldn't we have to find that to say that it met your client's obligation to file the claim, and so we would have to say, okay, then under the statute you file a claim by filing a petition for benefits, so therefore this would be a petition for benefits.
Yes, you would have to find that it's the equivalent of a petition for benefits.
And the statute says it will toll, a petition for benefits tolls, but only if there's certain specificity met within the statute, correct?
Yes, the statute does list certain things that have to be included. In this particular request for assistance, it included everything basically except for 2 things. But the judge's decision, that kind of raises another issue too. The judge's decision in this case doesn't say that the request for assistance lacked specificity or didn't include everything. He just said it doesn't toll the statute of limitations. His order really doesn't say why he reached that conclusion, but that's the conclusion he reached. And so my response to that is, if the request for assistance was deemed to lack specificity or not include everything that's supposed to be included in the petition for benefits per the statute, then 440-192-5 does give a claimant 20 days to amend if it's dismissed for lack of specificity. So if the ruling in this case was your request for assistance doesn't toll the statute of limitations because it didn't include everything, then I don't know, it seems like the claimant very likely would have.
But I thought the statute said that the only way a petition for benefits, and I'm assuming when the statute says that, they're talking about something that's called a petition for benefits and is in fact a petition for benefits, but then it lacks some of the specificity required, then the statute says it does not toll. So if we were to say that a request for assistance is now the equivalent of a petition for benefits, it would seem as though if the request for assistance would then have to meet the same specificity requirements petition for benefits would have to meet in order to toll the statute, and it seemed as though the request for assistance here did not meet those specificity requirements.
Well, there were 2 things. The carrier seems to think that there were more things that weren't listed, but it seemed like there were 2 things that were not included in there. I will agree to that. One of them was a detailed description of the injury and the cause of the injury. although that was in the notice of injury, and another was a detailed description of claimant's job, responsibilities, work. Those are the two things that really weren't in the request for assistance. But as far as whether you call it a petition or not, the Sanchez case that I cited, that was the reason the judge of compensation claims found that the request for assistance and claim that were filed at the same time did not toll the statute of limitations, because the statute said petition for benefits, and this court said that it didn't, just because it wasn't called a petition, the RFA and the claim was filed within the 2-year time period. Now, I agree that there is a factual distinction in that case. That case involved a date of accident before the January 1st, 1994 amendments. But I don't think you have to call it a petition. The second argument I have in that regard is there's cases that say if you call a petition for modification a claim, it's still a petition for modification, et cetera, et cetera. But I would agree that it is supposed to contain all of the information. However, and I understand 440, the section that says it's got to contain everything to toll the statute of limitations, but then you get to subsection 5 again, which says you have 20 days to amend. So that leads to the issue of would the relation back doctrine apply? It applies in civil cases. I did cite a case in my brief.
Or the statute that says so many days for leave to amend, does that specifically refer to the to amend to cure a lack of specificity? Or just its amending period?
It says it's 44192. 5, 2002, it says when any petition or portion of a petition is dismissed for lack of specificity under this subsection, the claimant must be allowed 20 days after the date of the order of dismissal in which to file an amended petition.
Well, how do you, if you read that together with the provision that says that unless the petition has the requisite specificity, it does not toll, isn't the natural reading that yes, you've got 20 days to cure, but until you plead with the requisite specificity, you don't toll the statute of limitations?
Well, I would agree that that could be a reading. I would think another reading could be that, because the amended back doctrine provides that if you file an amended petition, it relates back to the date of the filing of the original petition. I would think that could just as easily be an interpretation. I do cite a case in my brief, though, that wasn't the issue, and it does indicate that perhaps my argument might be wrong, but it wasn't the issue. That's the case of McBride versus Pratt and Whitney, 909 Southern 2nd 386. But our position is that an RFA, if it does contain the information required in the petition for benefits, should toll the statute of limitations, since it's not a pre-petition requirement anymore. I'll reserve the rest of my time for rebuttal.
Okay, we'll reserve your time.
May it please the Court, I'm here on behalf of the employer, PennStat, and its St. Paul Travelers, the carrier in this workers' compensation matter. I'm going to take a calculated risk to get the Court's attention focused on the real issue here and start with the words, is this trip necessary? Why are we here looking at a possible bend or alteration of an area of the law that is already troubled, and I don't think you could summarize in a nutshell anymore the statute of limitations cases in workers' comp. And here's the calculated risk. That last case that we just heard seemed pretty important to the plaintiff in that case. This case doesn't. Now, I would expect somebody to jump on me and say the worker's case is just as important, and that's where I would interrupt and say, no, not by this worker's actions. This worker sat on her rights. She showed a lackadaisical, if not a complete Rip Van Winkle approach to her claim. She ignored calls from the carrier. It was a questionable claim to begin with, and the questions of fact were resolved against her. She denied getting ever notice of the initial informational pamphlet. She had treatment for similar symptoms months before this occurred and denied them. She had no lost time for 2 years. Filed the petition at the eve of the end of her statute of limitations, which is also the end of the 104 weeks of entitlement to temporary benefits. So she had very little to talk about, even with her claim, and she has an attorney, and they filed the wrong document.
Doesn't it really appear as though that's the real error here, that her attorney misunderstood the obligations that were, in essence, thought that the request for assistance was required, filed the request for assistance, waited 30 days for that, and then filed the petition for benefits? Doesn't it really just seem as though they misunderstood the statute and we have an attorney's error here?
Well, living in a glass house, I'm reluctant to utter those words, but I would say that the wrong document was filed by the counsel of record. And here's where I'd like to get into the argument proper. The statutes are crystal clear here, and I'm going to bring the resolution of the two conflicting matters to Judge Benton's attention. This is a statute that says, attorney beware, parties beware. This is a very potent language we're going to see in a moment here. But what you have here is a brief that says multiple material instances of ambiguity are the substantive equivalent of specificity. He argues at page 2 in the reply brief. And an X is readily inferable as an attorney's certification, which he argues at page 9. Those are two of the ones he's left out when he's done a lot of stretching to make his last two the only omissions. There were numerous omissions. Page 12 through 15 of our brief articulates the omissions. He's done a lot of stretching to leave it at just two. But here's the interesting thing. He does not cite in his initial brief the statute that I'm about to point out to you, and that is section 440, 1(9), paren 1 and paren 3. And that says petitions shall be barred unless it's filed within 2 years. And 3 says, the filing of a petition for benefits does not toll the limitations period set forth in this section unless the petition meets the specificity requirements set forth in section 440, 192 Florida statutes. That's clarion call to those who would attempt to file on behalf of the worker what they must do within the time frame. Now, counsel did not raise this in the brief, so I did it in my answer brief. And in the reply brief, he says the judge didn't rule with specificity that was the reason for the denial here. Well, again, we get the substantive equivalent. The judge says, quote, the request for assistance dated 5/23/05 does not toll the statute of limitations. If there was something bringing ambiguity to claimant's counsel's mind, a rehearing might have sufficed. I say it sets the stage perfectly well for the argument I'm about to make on the basis of the statute I've just read to you. It says, Your Honor pointed out, or attorney counsel argued in his reply brief, just as he did a moment ago, that there's this other statute, 192, paren 1, says a petition which meets the requirements and the definition of specificity, and then it says, upon receipt, the judge, the OJCC, shall review each petition and shall dismiss each petition or any portion of it that doesn't on its face meet the specificity requirements. Then here's what he's hanging on. 5, all motions to dismiss must state with particularity the basis of the motion, and when a petition is dismissed for lack of specificity under this subsection, the claimant must be allowed 20 days. So, we have two statutes that seem possibly in conflict. Your Honor pointed out one way to differentiate them. I point out another. There are two situations specified. Only one of them is before the court today. Was there a motion to dismiss? No. Was there an order of dismissal? No. The literal and express triggering mechanisms for this limited grace period do not apply. There is no conflict. The provisions are crystal clear. And certainly we have no justification or compelling exigency in this claim to do violence to the very plain language of section 440.19, paren 3. Where it's that clear, this court knows very well there's no reason for interpretation. It would be an error to go behind the plain language that the legislature has brought to bear in these particular provisions. They could not have made more clear their desire to eliminate some of the older case law, that any piece of paper that arrives somewhere is going to be given the benefit of the doubt. That's all been repudiated, and the court's own cases show the process. And we have the cases cited. Just to walk through some of the highlights, Vilches versus City of Dunedin certainly says that a RFA is not a claim, then it certainly can't be a petition.
What are you saying? You have cases that hold that a particular petition is insufficiently specific?
Well, no. The case I just referred to as an RFA is not a claim.
No, you don't have any cases that tell us what is.
Well, yes, I do. I think Kennedy versus Orlando Shader Realty says substantial compliance argument is unavailing, and yet at page 2 of their reply brief, It's their whole basis for their argument, that the rough equivalent will work. Here it says substantial requirements with the statute by providing sufficient information to allow the employer carrier to understand the benefits sought. Substantial compliance is an argument without merit. The petition must identify or contain on its face the information of 192. That's in the Kennedy versus Orlando Shearer Realty case, which is in the briefs at 711. I think we miscited it. 711, page 156, Your Honor. Now, I'd like to turn the tables on my worthy colleague who in 1998 got a case reversed that I was involved with, Cadco Builders versus Roberts. That case involved interpretation of this court's interpretation of the non-final order provision, the Workers' Comp Rules of Procedure 9180, paren B, paren 1, paren C, which says that requires an express determination that those benefits will require substantial expense and time within an order. That order must contain that, or it's going to be dismissed as a non-qualifying non-final order for appeal. This order that I was representing the JCC on effectively noted that the parties were interested in reducing the cost of further litigation and that in deciding to bifurcate the proceedings, he gave consideration to the substantial amount and variety of benefits in dispute. This court says that was not the substantive equivalent of that very precise statute. And I think it's the worm has turned in terms of that type of argument. And again, I have to stress, as we did in our briefs, that where the legislature has made such a clear statement of its intent in this area, which does clean up some of the prior older cases where it talked about any old thing that came in could be a claim maybe. Nothing could be clearer than the statute I've just read. And the cases that the claimant cites are just unavailing. Here, the core argument is at page 2 of the reply where they think the equivalent language. It just doesn't apply when you have so many omissions and material defects in the order. Your Honor, I could take you through some of the other defects that I think permeate the order.
Well, he says the basic omission is failure to describe the circumstances of the accident, including the location, and what type of work was ongoing at the time of the accident, and that this information had already been furnished to the employer at or about the time of the accident before the employee was taken to the hospital.
Well, there are other documents in the workers' comp program. This particular statute refers to the one in play now, the petition. Now remember, you have a stale claim to begin with. That's why this petition, that's why there is statute of limitations. So you come at the very eve of the time period within which to file for no good reason. We're all here for no good reason. I'd like to stress that. And the exception that you might contemplate in grafting will disturb the status quo, again, for what cause exactly? I don't think the trip that I point out at the beginning is worth it. But there are other defects. I point them out. I'll begin at page 12 in the brief. It doesn't describe the location, the occurrence, the date, even the date of accident. It really doesn't matter that it is contained in a...
It gives a date, but maybe not the
That's right.
date.
That's right. It doesn't specify the specific classes of benefits that were not timely provided. It merely says payment of TTD, TPD from date of accident to present and continuing. The statement is inherently defective in all its parts. She was working the entire time, so she could not be entitled to TTD. There is a period where she earned less. Claimant in his brief concedes it wasn't related to the accident, so she couldn't be entitled to TPD. She reached 104 weeks. There can be no continuing benefits. So none of that was specific. That's what the legislature says. What is your problem? We've had problems in workers' comp with shotgun claims. We want specificity. We could not make it any clearer.
Are you saying 104 weeks begins at the date of accident and expires 2 years later?
I think so, yes, Your Honor.
So you don't think it begins when you start getting benefits?
No, I don't think it's a
Are you saying that if she was eligible for those benefits, she would have gotten back benefits and it would,
the point is the case was
and it would be
dismissed.
nothing continuing?
Well, having been dismissed on the statute, I prefer to simply say that this was not a specific pleading. TPD, TTD in the past from the date of accident and continuing. They were not due, so couldn't be specific, and continuing, they would have to have a starting point. She was not working. She did not lose any time but 2 days in this case from the whole 2-year period. So that could not be a specific claim of what is ailing you, troubled worker. That can't be specific. That's my point in referring to it, not that she could not conceivably win those one day. Remember, every statute of limitations case the legislature understands could harbor the ruin of a very significant loss to the worker. But there are social policies supporting the application of the statute of limitations, which I cite in some of the briefs. Every statute case that's granted lies the ruin of a denied claim. This one is not particularly compelling, but I'm only referring to specificity now. It requires petition mention the date of maximum medical improvement, the character of disability. The petition makes no mention of either of those things. And finally, it requires a certification that counsel has contacted the parties in an effort to resolve it. And again, the certification, which has a word in law, a word of art, is satisfied by his readily inferable, quote, page 9 in his reply brief, readily inferable from an X on a form. That's not a certification. Again, if we allow this specificity statute to be accepted by a case that asks for the substantive equivalent of numerous written parts of the components of the petition and several omissions, you're inviting a troubled sea in an area that I've already described has got a lot of exceptions engrafted onto it, and it's pretty hard to put into a nutshell. There is no compelling exigency demonstrated in this case, none whatsoever, that can trump the very valid and very precise and robustly precise language of the statutes at issue. There is no reason to tamper further with the statute of limitations law, and we would ask that the judge's order be affirmed, Your Honor.
Thank you, sir.
Just briefly in response, I want to say the reason we're here is because if the claimant loses, the claimant gets no compensation benefits. It is important to the claimant. And I admit that the RFA or petition for benefits or whatever it is does have to list all of the items that are in the statute in order to be a proper one. However, the judge didn't dismiss it on that grounds. He just said the RFA does not toll the statute of limitations, and as we stated previously, if it was dismissed for that, perhaps they get a right to amend, and perhaps it does deal with the relations back doctrine. Maybe that's the issue for another day. But right here, the judge just simply said the RFA does not toll the statute of limitations. As far as some of the other things he's saying about specificity, the RFA specifically indicated the items that the lady wanted. Whether she would have gotten it or not at hearing, I don't know. The judge denied them all because of the statute of limitations, but she wanted the compensability of the date of the accident. She wanted authorization for evaluation and treatment of her hips and low back. She wanted authorization for evaluation and treatment with a neurologist, payment of TTD, TPD from the date of accident to the present, determination of AWW. I mean, that's pretty specific. It's certainly specific enough, I would think, for the statute. But we appreciate the court's time. Thank you.
Thank you. Thank you both.